welcome to the the Honolulu Ethics Commission meeting. My understanding that we do have quorum. Here we have.
Oh, here he is.
Okay, Ken's there. Okay, there. All right. Would all the commissioners indicate whether they are present?
You want to call my?
I'll call my name. Yes. Sheldon Jamon, present.
David Monk.
Peter Adler.
Linda Martell.
Cynthia Lynch.
And Ken. Ken?
He's muted. He's muted. Unmute.
Yeah, present.
Okay.
Okay, I finally connected.
Okay. And for,
Say
Yeah.
anybody in the room with him.
and Ken, I wanted to ask, and Commissioner Fukunaga needed to ask whether there's anybody in the room with you that are present or,
No,
okay, you're there by yourself.
I am.
My understanding that Commissioner Rice is ill and could not attend. Okay. Before we start, are there any members of the public present who would like to identify themselves and address any agenda item? None? Then let's move on. Let's move on to new business. I don't have any announcements, introductions, or correspondence, so I'll go right into the request for the approval of the open session minutes of August 20th.
Move to approve with one correction.
Why don't you make that correction?
Sure. Under item Roman numeral 2A1A. I don't have the full minute in front of me at the moment, but it's a very minor correction. Currently reads, Vice Chair Monk noted that the rules be similar and not exactly the same, comma. I want to change that to noted that the rules may be similar, and adding the word may because it doesn't scan.
Yeah, I did that too. And that in mind too.
One second.
Okay, was there any second of? the
I'll
amendment?
second that too, and second the motion. If I can.
Any discussion?
Who made the motion?
Motion moved and second, okay.
Yes, Vice Chair Monk, Commissioner Adler.
And Commissioner Adler seconded with
Seconded
the
as
amendment.
amended.
And now, for any discussion? Hearing in none. Does anybody disapprove the minutes? We'll put it in negative that way. Hearing no objections, the minutes of August 20th, 2025 are approved with the amendment as noted by Vice Chair. All right. Another thing for action is the approval of the open session minutes of September 2nd, 2025. Does anybody want to make a motion on that?
What was it?
I'm sorry, it's September 2nd, 2025.
September 2nd.
It's a second
Okay.
round of minutes.
I'll move to approve.
Second. Monk seconds.
So it's been moved by Commissioner Martell and seconded by Vice Chair Monk to approve the open session minutes of September 2nd, 2025. Any discussion? Any objections whatsoever? And with no objections, we'll the open session minutes of September 2nd, 2025 are approved. Next, up for action and discussion are the time limits on testimony. The director will give us some background concerning the recent information for memorandum received from OIP, the Office of Information Practices, concerning imposition of time limits on public testimony.
Thank you, Chair. Good morning. This is Jan Yamani, Executive Director and Legal Counsel. The Office of Information Practices, State OIP, has been issuing a lot of little updated opinions or informal opinions to help guide public meetings. One of the things that they've come up with has been that boards and commissions may limit the length of testimony by public testifiers. But if you wanted to enforce that, you'd have to have it written somewhere. They say by rule, but they've clarified that it doesn't have to be by an administrative rule and that it can be merely noted in the minutes, and that would be something in writing. Just for your information, in our agendas on the first page, as well as the third page of this present agenda, we do state that each speaker is limited to a 3-minute presentation on each item. And so that is at least stated within the agenda. If the commission ever wanted to enforce that 3-minute rule, we would recommend that you put it in the minutes as a motion and a vote. And that way it would meet the standard of OIP for a written policy.
Actually, what I would make a recommendation, suggestion that we adopt this formally for a 3-minute rule, with the exception that the chair has discretion under the circumstances to accord the speaker more time.
So moved.
I'm sorry, who?
I move.
Moved and seconded, Lynch.
It's been moved and seconded to adopt the recommendation of limiting public testimony to 3 minutes with the added discretion of the chair to increase the time or accord more time to the public speaker on its circumstances.
Yeah.
This is moved and seconded.
Yeah.
I'd like to have a vote on that.
Can I just talk about this for just 1 second? I'm so sorry. This is Moana. Can you hear me?
Yes.
Okay. If you allow someone more time, you have to allow everyone more time. So it's not on a speaker by speaker basis. It's at the beginning of the meeting, you will allow either the agenda item speakers more time or the entirety of the agenda more time for each item, but it's not speaker by speaker. And the 3 minutes does not include questions from the commission or the responses. I just want to make that clear.
Yeah, I understand that.
Yeah, I was going to suggest a friendly amendment actually to specify the last thing that Moana just said, which is that the chair could extend the time at his discretion for the purpose of responding to commissioner questions
At his or her,
at the chair's discretion.
yeah, the chair's discretion.
Does that work, Moana?
It does work, but you can just have it be implicit as well, that it does not, the 3 minutes does not include questions from the commission to the speakers. The speakers
Right.
should come in
Spell it out
knowing
as
that they have at least 3 minutes to speak about what they want to speak about, which does not include questions and responses.
So is anybody suggesting an amendment to that effect, that the 3 minutes of testimony does not include questioning by the commissioners?
Sure. I'll move that amendment.
Yeah, friendly amendment.
Yeah.
Anyone second? Commissioner Adler? Any discussion? Okay, with that, with this first and second amendment to the motion, that we need, as a rule, limit public testimony to 3 minutes at the discretion of the chair, to accord more time to the
You got that?
testifier, and that
No, we should write this down.
and that the 3 minutes does not include questions by the commissioners.
And there's questions and responses.
That's the full motion with minutes. Okay, all those in favor? Aye. It's passed unanimously.
What rules?
Okay, the next item for agenda is For discussion, the ethical guidelines of artificial intelligence usage in the city and county of Honolulu. We put this on the agenda at the request of Commissioner Fukunaga and Commissioner Rice. Ken?
So this was more a question from me about whether the commission, Ethics Commission's purview includes something like setting out guidelines or guidance on the ethical use of artificial intelligence by employees of the city and county. And whether that's been done by another agency or the mayor's office or something else. It's more an inquiry for me. Because we're going through this currently, with the judiciary on the joint Hawaii State Bar Judicial Conference Committee. And so I thought this is something we could address only as a question at this point, and whether it's something the commission wants to do or not. I just don't know.
Commissioner Lynch?
Well, I'll just say I'm a lifetime member of the American Society for Public Administration. And as a professional organization, we've decided that if a declaration of whatever we're submitting is generated with the assistance of AI and list whether it's Copilot or ChatGPT or whichever one has been used, but it's with the assistance of. And so it becomes like a declaration. If we're publishing something that's been published somewhere else, but it's a little different, we have to say where the original thing came from. So it's just a matter of acknowledgement, not prohibiting it, just acknowledging it.
Well,
I have some information to add. So
okay, well, let me just finish up with my information. My information is that agencies currently are doing that. They're summarizing documents and document requests, especially to the press. And these summaries may not accurately reflect the document itself. So what my understanding is occurring is that the attorneys representing the various agencies are requiring disclaimers. It simply states that we know that this summary has been made through artificial intelligence, and this summary may or may not correctly reflect the original document. So that, with this disclaimer, they feel they can do it, because with the press asking for instantaneous summaries like that, they want to, the staff cannot keep up with it. So they're doing these summaries for the press. And mainly that's where it's happening, not on an official document, but they recognize that, even with a summary is an official document. So with those disclaimers, the agencies, I know some of the agencies are moving forward. And I think that, just an interesting point.
Curious how enforcement works.
It probably is enforced agency by agency. The director, the director wanted to say something.
thank you. So we understand that the Department of Information Technology, so that's DIT, is currently drafting a citywide policy with general guidelines on city use of AIs. It's kind of like when issues came before us on social media, and it turns out that the Department of Human Resources was the lead agency in drafting such policies for kind of social media use for the city. We inquired with Corporation Counsel, and Corporation Counsel does have its own use policy. It has come up for us we just did some training, which we'll report on later. It was one of the COCO Connects on writing investigation reports. And it turns out that a lot of the other either campaign spending, elections, ethics boards and commissions across the country are starting to use AI for a lot of its investigative report writing. The concern that we have, and we understand that different platforms do it differently, but the concern that we have is that we don't want our information to be stored anywhere, because our understanding is some AI gets stored so that it becomes, kind of that redundant knowledge.
Yeah.
So if we're going to use it, we have to be pretty sure that whatever platform we use does not store our information, because otherwise we could be inadvertently releasing confidential information. So we're still at the point of kind of looking at how it's being used. We know that other agencies have indicated that it's really good for digesting big documents or say email polls, something that's voluminous. That if you put in the right search functions, it actually does a very good job. So we're at the point of looking at it, but we ourselves have not developed a policy specifically for ethics.
So, Jan, you've addressed actually pretty much what I was going to bring up to, in that it seems to me that like social media, there should be, and probably the city thinks as well, there should be a citywide policy rather than an agency by agency policy on use of AI. And to the extent that Ethics Commission believes that we have something to add to that, we should probably be in touch with whoever is drafting the overall policy, whatever input we think might be appropriate from our point of view, but we shouldn't be trying to issue a separate Ethics Commission guideline on AI. Should be incorporated to the extent that we have something to say to the citywide guideline. And you're also, I think, talking about two separate things. One is the citywide policy, and the other is what are we going to do with it within the office, and that may be a separate issue.
Mm-hmm. I know that our investigators have already tried with kind of just bogus, facts, just to see what it would come up with, and the results are quite good. I know the caveat is always there must be a review by human eyes, but even so, it may help us with our investigations.
Is there any more discussion?
So Chair,
Yes, Commissioner Fukunaga.
maybe the way to go ahead with this is get a report back from staff at the next meeting about what is being done at citywide, in terms of monitoring and providing guidance on the use of AI, just so we have a better idea of whether there are any ethical issues we should address or not. And let me just give you the background for this. So not just the joint committee I'm on, but my daughter serves as a deputy director for records and archives in the state of Indiana. And that agency just issued for the entire state guidance on the use of AI. And it has certain portions of it which address what you just said about not putting anything confidential in the prompts that you're asking for output back from AI, because some of that does end up on the internet. So that becomes more of an ethical issue, I would think. And the ethics issue also arises there are over 100 legal cases across the US now and worldwide, where courts have weighed in on what should be done. And normally they end up with referring only to Rule 11 for lawyers, which is the ethics rule, essentially, about how you conduct yourself in court. So that's the background of why I mentioned this currently. And it could be the city is already doing this, through the IT department, where you would expect guidance to be issued.
So you're requesting, Commissioner Fukunaga, that the executive director ask the staff if they've made communications with agencies or the IT department as far as what they're doing about AI.
That would be my suggestion, so we can just cross this off the list if it's already being taken care of. And there are no ethical issues to address.
Did you understand?
Yes.
Okay. Would you be able, Director, would you be able to report next meeting, which would probably be in December?
Yeah, we can reach out to DIT and find out, where they are in their policy drafting process. I think that would be kind of the lead piece, because it would be a citywide policy. And then we can take it from there.
Personally, I would feel reluctant to issue citywide policy from the Ethics Commission on this issue. particularly as it applies to court counsel, which is and the attorneys that are governed by some other licenses,
Right.
like the judiciary and disciplinary board.
Well, as I said, Corporation Council does have its own policy
Yeah.
that is specific to Corporation Council for its use.
And other agencies have their own, which I understand are specific as to their own policies because of the type of information that's
Yes,
going
I
out.
believe so.
So there may be various variations. So, well, I think Director will go ahead and investigate whether or not IT department is working on the guidelines citywide. I don't think we're at a point where we're going to be asking about whether our commission itself is. We're not at that juncture yet. Is that okay?
Yeah, that's fine with me. I think we just address it, and if it's being taken care of, we can move on.
Okay.
Thank you.
And we'll put that on the agenda for the next December meeting. Get a report back from the director. Next is the executive director and legal counsel's report.
Thank you. Good morning, everyone. You'll see the staffing report, the work summary reports in the meeting materials. On slide 7, item 1B, Americans with Disabilities Act compliance. I wanted to put this on the agenda for the purpose of letting the commission know that this project is across the board in all government, from the federal down to the state, down to the city and the other municipalities. There is going to be an intense staff impact for us. We are required, as all government is required, that the entire website that we have be ADA accessible by someone that is sight impaired or has other challenges to being able to read. Our site is much deeper than most sites at the city. We have over, I think the count was 400 advisory opinions going back to 1967 posted on our website. Many of them are in very antiquated form. Some of them have charts, others have footnotes, some have appendices, others have redactions. It is going to be a huge challenge for a small staff like ours. I know to have to ensure that all of those materials are being made ADA accessible. We have changed some of the features, and if you go to our website, you are going to see changes. There are some features that are not easily made ADA accessible, such as the carousels. We used to have sort of sliding in and out new newsletters or new training, annual reports. We understand that those features are extremely difficult to make ADA accessible. I think it's because of the movement. So in those cases, we've taken them down to static tiles so that they'll be easier to just isolate and describe. We've also been told that it's ideal to have one document that is ADA accessible. You cannot have one document and then another one that's just plain text that's ADA accessible. The base document should be ADA accessible. It is in fact a huge challenge for training materials, our newsletters, our videos, brochures, even the annual report, anything that we put out that's in the written format, that each and every heading, picture, chart, you name it, anything in a printed material be ADA accessible. The deadline across the board is April 24th, 2026. For us, we started, I think in the middle of the summer, Assistant Executive Director Myra Sang went through the ADA to ensure that we understood what our charge was. We have communicated with the Equal Opportunity Office here at the city and asked for their assistance to read some of our materials to see if we're doing it correctly. We are trying to get ahead of the ball. There is a time frame that EOO did put out. But unfortunately, it lands right on top of our heavy filing period in January and February because everybody's looking at the March-April deadline, deadline in April. So many of the agencies, I think they expect will be doing some of the heavy lifting in March and April. Well, we simply can't do that because January, February, March is our filing period for lobbyists and for annual financial disclosure. So we're trying to front load a lot of the work now, trying to balance it with when we know the avalanche starts with the lobbyist filings in December, and then it gets added on with financial disclosure annual filings. It is going to impact our work across the board, we believe. The legal clerks, we've divvied up the whole website into various buckets of responsibility. Leland is primarily in charge of meeting materials, meeting agendas, minutes, all have to be created in styles in order for the metadata to be impressed or embedded in the documents. Training specialist Aoyagi is doing all of the training materials. We have any number of different staff assigned in various places. The lead for the advisory opinion, the 400 advisory opinions will be our legal clerks, who are also the leads when it comes to lobbyist filings and financial disclosure annual filings. Hence the heavy lift. We're trying to get ahead of the ball, do most of it now before we get into January and February. It is going to be an immense staff impact. So I wanted to let the commission know because there may be some requests that are asked with certain delivery dates, and we simply may not be able to get to them because of this additional project that we understand the date is a hard and fast date. We've taken training, both federal training as well as city training, on how to best convert some of these documents and other materials. We understand that there isn't any across the board city guidance. So we are reaching out to various state ethics. We're reaching out to them to see how they're managing. We're reaching out to other agencies for guidance to see if they have any tips to ease the work or to help us get ahead of it. So I'm happy for any questions. I just wanted to let the commission know that this is a big project with a drop dead date.
What do you have to do? Convert things to Braille and Audible?
It has to be so that when a person, as I understand it at least, when a sight impaired person hovers over the materials, the reader, oftentimes there's a reader that's an audible reader, will say, if you're looking at this slide, for example, it'll say to the Executive Director and Legal Counsel's EDLC report. If you hover over the logo, it should have a description of logo, bird flying across water in compass format or city seal. So both the graphics, any graphics or visuals have to be described, as well as all of the words need to be read. We've found that there are some just straight text documents that aren't so bad. They're a little easier to convert. It's the ones that have the footnotes or the endnotes or the appendices, or in some cases, we've taken pleadings and redacted names, redacted personal information. The readers often don't know what that is. Or sometimes if it's I guess if it's a picture, it's a visual, it'll just skip over the whole page. So we're going to have to ensure that every single page of every single AO be readable by this other format. It's a bit of a challenge. We're still trying to figure it out. But again, it is going to have a big staff impact on a staff the size of ours. So just as a heads up to the commission.
Take up a collection for white lilies
Yeah.
to send to the office.
So anyway,
For condolences.
yeah. So I'll move on. We are still in recruitment for an associate legal counsel, and we hope to have one on board very, very soon. On slide 8, the statistics, the monthly totals, we are showing our requests for advice received and answered in the months of August and September. Statistics, the monthly totals for the concern forms that were reviewed for August and September. On slide 10, the statistics monthly totals of investigations, active investigations and closed investigations for those same months. Moving on to slide 11, I'll turn this part of the meeting to training specialist Aoyagi.
Commission, good afternoon. To start, pleased to announce we've reached 100% compliance in our board commission training. Lots of nagging. We just want to thank everyone that helped us get to 100% compliance. And we're prepping for the next biennium. Doesn't stop.
Yeah. If I may interject, it's unfortunate that we're now in October and I think we only achieved compliance in September, 9 months after the December 31 deadline. There were numerous challenges that we faced, most of which were out of our control. And many of our commissioners, some of you know those issues because we also did some in-person training to get around the logon issues that seem to persist. We have worked with the Department of Human Resources, that is the administrator for the Honolulu U Learning Management System. We want to try and get as many kinks out as possible because, as you know, we are going into the second year of the biennium. And in January, I think we're planning to launch our next round of training. So they will have from January until December 2026 to complete the training. We're hoping for a better solution this time around and that we won't run into the same problems that we did the last time. Certainly not completion by the following September, hoping for a closer to December completion deadline. I think many commissioners now know what kinds of IT issues they're going to face. Or in some cases with private companies, we know there are firewall issues as well. So those are all things that we're beginning to understand better. Hopefully the learning management system and DHR as well as information technology can assist more with making those trainings less cumbersome for board and commission members. Thank you.
Yes, so we'll keep you folks updated. Moving on to slide 12. We had our October 1st pop-up table at Kapolei Hale. We had 14 people stop by, and of those 14, 10 people played our games. Your flyer is in your meeting materials, and then we have one more pop-up table at the Fosse Municipal Building November 5th, and that'll be our last one for the year. Okay, slide 13. We released our September newsletter, Ethics in the Stars, Ethics Monthly Horoscope. It was fun and different. A lot of people seem to enjoy reading it, so it's also in your meeting materials. And then just recently, we released our October backup pay stubs, BOPS gift giving guide. And this one's part 1 of 2, so there'll be a part 2 released October 31st. Now, this is something that we found out before, or just recently, but we are planning a tour to the Department of Parks and Recreation. It will be on November 7th. It's still a work in progress. We don't have the schedule yet, but it's still being made. There is a van that will be taking staff. There will be 1 seat available for any commission who would like to join us. But I'll try to get more information and send over that to you folks in case anyone is interested.
Well, we understand from the department that it's a multi-site
Yes.
visit. And so the van will take you from location to location. One could drive oneself if you know where these places are, but the van was intended to just be able to move a lot of people in one movement without everybody driving off into the distance.
And so where would the van start from?
From
start
our
here.
office
From here,
here,
okay.
yes.
First stop was the City of Ottawa and Recreation and Parks Department. Nostalgia.
If there's no questions, then I will turn it back to Jan Imane.
Thank you. So I'm on slide 14 now, on Kogo Connects and blogs. On that first item, make it make sense, effective report writing for investigations and enforcement track. There has been a very good investigation and enforcement track Kogo Connect in this last fall. And that may have been an outgrowth of, I think there were some comments at the last Kogo meeting, the Kogo conference, that there didn't seem to be as much enforcement track items. And so I noticed that the beginning of this year into the fall has had a very strong enforcement training track. The report writing, unfortunately, our investigators are on leave and can't report on this. I know many of us attended. There were a lot of very good sort of reminders and things to keep in mind when you write your reports. And this is where we heard about a lot of the AI use. Many of the report writing is being done, even in the first draft, or some of the components of the report are being done via AI. I think our next move is to probably reach out to those departments that are using it to find out which one they're using. Are they concerned about their confidential information getting out there in the learning bot someplace? So that we can follow suit with something that's going to be pretty, we have to be very sure that our information is not going to be out there in the cloud. So that is one challenge, but it was nonetheless interesting to hear it's being used so widely among certain investigation agencies. The other items here, the efforts to dismantle Watergate, I don't know if anybody attended that one. Or on slide 15, there was a training track, strategies for increasing compliance and engagement and training. Did you?
Yes, I attended.
Would you like to report?
Yeah, it was really great. They shared different strategies to make training a little more exciting, you know, be able to make it funny or have a theme to it and try to not reinvent the wheel, but repackage it in a way that fits their audience specifically. So it was nice because it's kind of stuff we're already doing. So yeah, it was pretty good.
I understand that, I think with the ADA compliance for videos, in addition to the captioning, there also has to be sound effect descriptions and visual descriptions. I don't know if any of you turn on your closed captioning when you watch Netflix or some of the other streaming, but you hear the horse and it says horse nickering, or you hear the wind, you know, the big gusts of wind and wind howling. Evidently, our training materials have to have that as well. So I think on one of them, there was a bus or a trolley with a bell ringing. The video itself is going to have to describe trolley driving, motor, sound of the motor, bell ringing, in addition to the closed caption. So it's going to be really different. So thank you in advance for making all of our training materials ADA accessible. There is another training coming up on October 20th, Georgia in Focus, addressing voting and election issues from the Peach State. We'll capture that in the December meeting if anybody attends. Finally, the Council on Governmental Ethics Laws Annual Conference on slide 16. Chair, I don't know if you wanted to
Yes.
take on this discussion.
Let me add two things, a few things. First of all, as to which commissioner would be attending the Atlanta Kogel Annual Conference, it was decided by the flip of a coin between myself and another commissioner. And so it was this, I guess I won the flip. Therefore, to announce that I'm going to be at Atlanta for a conference, I look forward to it, and I'll report back to you. The other thing I wanted to indicate was that at our previous meeting on September 2nd, in the discussion of the December 2024 Kogel Conference in Atlanta, or the national conference, there was a statement made by a commissioner that some staff members had failed to attend the mandatory meetings with the State Ethics Commission. My understanding is that the commissioner has since personally apologized to the staff about questioning whether they had attended in all sessions and whether or not there was a mandatory session. But at the request of the staff, I'd like to clarify that Vice Chair Monk did call the State Ethics Commission, and the State Ethics Commission has said that he was unaware of any mandatory meetings. So, and the staff has affirmed that they fully participated in the conference daily from breakfast through plenary sessions, breakout sessions, and optional evening events. The purpose of my putting this information here was merely to correct the record from last time. And if anybody wants to add anything,
Well said, Chair.
Thank you for your assistance. You made the call. State ethics. Thank you so much for calling.
Oh, excuse me, this is Jennifer Hubert, Legal Clerk. Commissioner Fukunaga, if I may ask if you could put yourself on mute, there seems to be some feedback coming through when you're not, then of course unmute when you're ready to speak. Thank you so much.
I thought it was coming from us over here. Also on the agenda is for discussion, the Ethics Commission and staff attendee selection process. Now, that was specifically requested by Commissioner Rice, we put on the agenda. And with respect to the staff attendee selection process, my thoughts are that it should be left with the director to decide, because we as commissioners should not be discussing in the public as to who or what staff member bears merit in terms of attending, and it gets too personal on that level. And however, I did agree that with respect to future attend, if there's more, if there are funds available for a commissioner to attend, it might be wise to select the process at the time to decide which commissioner should attend, so that maybe you avoid these coin flips or pulling of straws or anything like that, if you're so inclined to do so. I'm just bringing it up for discussion.
Coin flips are fine.
Drawing straws are good too.
Yeah.
That's fine with us.
We have plenty of time before the
Yes.
next conference to decide if we want to have a process, but it's worth considering the question.
Yeah, it's worth considering.
We can add it to the strategic plan whenever we get back to it.
I just gave my 2 cents about about the commission deciding staff attendees. And it's my preference that we do not do that. But with respect to commissioners, we have enough time to decide if we want coin flip or some other process.
I think, Chair, if I may, I would speak in favor of, for staff attending, generally in favor of the commission being in favor of a transparent process and not go beyond that in terms of detail.
Okay.
Would that be an acceptable statement? I mean, it's my personal statement.
I agree. We're trying to be as transparent as possible. But this is just for discussion.
Yeah.
Is there any other discussion? If not, we'll move on to the big agenda item, which is approving the administrative pre-public hearing revised draft administrative rules. And I will allow the director and of course the associate legal counsel to discuss the final revisions to those administrative rules.
Thank you, Chair.
Go ahead.
Go ahead, do you want to-
Sure.
Thank you.
Good afternoon, everyone. Thank you for being here. So, for this meeting, I basically resubmitted the materials from the last meeting, which were basically it's a revised justification memo and the revised gift administrative rules based on the discussion that we had at the last meeting in September. What I added to the justification memo was, basically the revisions that the commission wanted us to make for the rules. So if I could kind of follow the same, I guess, pattern that I followed last time, I'm just gonna walk through each section of the rules. I'll talk about what the request was and the changes that we made. So, section 7-1-1, it was the scope. There were no comments to that, because it was brand new. Moving on to section 7-1-2, which encompassed the definitions.
But I'd like to, before you go,
Oh, yes.
the director did have some small little changes. I guess, she discussed more about
Okay,
making some abbreviations. Why don't we include them into that?
okay.
And so that we can include them now in each session, if it's okay with you guys. She had some small
Yeah,
comments.
have some small, okay, sure. So these, the comments that I'm gonna make are all technical, non-substantive changes. They are for clarity and style. I referred to the Legislative Reference Bureau Administrative Rules Drafting Manual. And there were some, little ways to say things, ways to phrase things, et cetera, that they recommended. And so I will add those after we finish each of the sections, just so that we can have it in the record. In the first section, 7-1-1, I believe state is missing from Hawaii Constitution. And so I would recommend that we add state after Hawaii, in the citations of authority.
Okay,
Okay, go ahead.
for discussion, section 1-2, go ahead.
Oh, okay.
With that change, with these small little technical things, I don't see a problem with that. We can move to adopt the whole thing all at once.
Okay, section 7-1-2, the definitions. The commission recommended that we add a citation to the Hawaii Administrative Rules, section 21-7-1, which is what we did. So we added that. And just as a reminder, section 21-7-1 of the Hawaii Administrative Rules actually cites to Internal Revenue Code, section 501c3, so they're basically synonymous. In addition, the commission recommended that for the term dependent relative, they wanted to include a reference to the Hawaii revised statutes. So we found a consistent definition within HRS or Hawaii revised statute section 235-2.4 subsection A3. And that it's kind of a leapfrog, but there's basically 4 different references it takes, but it also eventually ends up citing to the Internal Revenue Code section 152A. So that was it. I think there's a final question about legislative action, that particular definition, and whether or not we could use the same definition that was in HRS section 97-1. And the reason we cannot use that same definition is because the definition is not the same. For the most part, it is, but at the end of the definition, it says proposed in the legislature. And for our definition, we say proposed in council. So that's why we can't use, and we can't cite to the HRF section 97-1. That's it for the substantive changes.
And then
Does anyone have any questions regarding the substantive changes?
So the last time under the legislative action, we discussed making reference to the statute, the HRS, but we couldn't do that. Or you're not recommending that because of the difference in the language. Instead of proposed by the legislature, it's proposed in the council. That's the difference.
That's the only difference. The rest of the languages tracks along with the definition, except for that last word, legislature versus council.
All right, then for the technical non-substantive changes, under charitable organization, the preference in the rules drafting manual is to just use commas. So the charitable organization means an entity organized under section 501(c)(3), comma, Internal Revenue Code of 1986, comma, as amended, comma, or section 21-7-1, comma, Hawaii Administrative Rules, comma, or both. So that would be the technical non-substantive change. Under commission, same thing, commission means the Ethics Commission established pursuant to section 11-107, comma, revised charter of the city and county of Honolulu.
Adding the commas and deleting off.
Of the, correct. Under dependent relative, has the same meaning as in section 152A, comma, subsection A, comma, Internal Revenue Code of 1986, comma, as amended, comma, or section 235-2.483, comma, Hawaii Revised Statutes, comma, or both. So this kind of language will be repeated throughout the rules.
Any comments to the technical non-substantive changes? Moving on to,
Go ahead.
okay, please. Moving on to Rule 7-1-3. Now, in this particular section, it's in regard to prohibited gifts. The commission didn't actually make any recommendations, but staff initiated on its own a change. We replaced administrative action with official action instead, because there is no definition that we provide for administrative action in our definitions, while we do have a definition for official action. So, at the end of subsection 1, it would state, or a lobbyist seeking legislative or official action from the recipient or the recipient's agency, as opposed to, or a lobbyist seeking legislative or administrative action from the recipient or the recipient's agency. So we changed it, if that is okay with the commission.
Yep. I
Okay.
don't see a problem with that. Go ahead. I don't think there are any
No,
technical changes.
okay, great.
So we can move on to 7-1-4.
So in Rule 7-1-4, the commission recommended to replace and use language from revised ordinances of Honolulu, section 1-19.7, subsection D. So this section talks about acceptable items. It provides exemptions to the prohibition on gifts. And the ROH section 1-19.7B is actually the gift law that's in our ordinances. So what we did was, in subsection B of the rule, we struck out the language, the no reasonable person would conclude, so on and so forth, and we changed it to gifts given under circumstances in which it cannot be reasonably inferred that the gift was intended to influence or reward, and it goes on. So that way it is consistent with the language in our gift law, which is, I believe, what the commission recommended.
And you struck out the last part, including if the donor does not have any interest. That recipient may affect in performing the recipient's city's duties. Right.
Correct, correct. Because that was actually, the language that was stricken out, the one that you just read, it was actually, kind of rephrased to conform with the law, and it's in the language above, the or secure for the donor or anyone else any unwarranted privilege, exemption, advantage, contract, or treatment that is not established by law or rule.
Understand. And there are no technical changes.
No technical changes.
Any questions on that one? Nope.
I think we're on to 7-1-6.
That is correct.
Five.
Five, there were no, recommendations by the commission. So yes, we're on to rule 7-1-6. And for that rule, the commission recommended that we replace and use language from Title V, the Code of Federal Regulations, section 2635.203, subsection F1. So that's the federal, definition, or federal, I guess, federal definition for indirect gifts to family members. We wanted to use something that has a proven track record. And we got rid of any kind of mention about consanguinity because that was very confusing. So that's what we did. We struck out, everything that was not consistent with that the Code of Federal Regulations. So we narrowed it down to a gift to a city officer or a gift to a city officer or employee's parent, sibling, spouse, child, dependent relative, or a member of the officer's or employee's household. So that is consistent with the Code of Federal Regulations.
Did you reference that? Did you reference the Code of Federal Regulations?
We have that referenced in our definition of dependent relative, I believe.
In the justification,
That references the Internal Revenue Code.
Yeah.
Mhm. So we don't,
The IRC is different from the CFR.
mhm,
yes, but when I looked in the drafting manual, it said to use the IRC.
Yeah.
Because that is more widely
Right,
recognized.
not the CFR.
Yes, they said that, well, the drafting manual suggests that the CFR, while it could be used, is more confusing than the IRC because the IRC is widely known.
But with respect to this part about a gift to the city officer of employees, parents, sibling, child,
mhm.
that comes, and et cetera, that comes from the IRC, not the CFR.
Actually, that comes from the CFR.
Yeah, that's what my issue was. The CFR is different than the IRC. I mean, having litigated both, I know that they're night and day.
One's a US code, one is a,
One is not.
yeah. Actually, in
They're
your,
just, one is the IRS administrative rules. And one is the Internal Revenue Code. And the CFR changes annually.
Well, I think the reference in the justification manual is to the CFR, part of file of the CFR section.
But you see my point, if you reference the CFR,
mhm. So there's no reference to the CFR in Rule 7-1-6.
yeah, there isn't.
No. Is that-
So the difference, the Internal Revenue Code is different from the Code of Federal Regulations. In that respect, Code of Federal Regulations is that promulgated by the IRS to clarify the Internal Revenue Code. But
That's
that,
like, oh, I'm sorry.
that may or may not occur, and that occurs annually in terms of amending the CFR. I mean, when I look at a definition to at the Internal Revenue Code, I have to keep up with the latest Code of Federal Regulations. And so either we quote it so that we have reference to it, especially this one, because this is the one that's going to be harped on as something novel different. If we went back just to the state ethics law, I don't think you'd have any problem, because the state ethics law is much, much broader, and it's not so specific. You see my point? Either we refer to the Code of Federal Regulations and in public hearings say, we got this from here, or we go and change it back to what the state ethics law says. And that way we don't run into any problems about the difference between the Internal Revenue Code and the Code of Federal Regulations, because, I mean, guys like me would know the difference.
There's, possibly two solutions, maybe. One, could be, and I don't know, Jan, maybe correct me if I'm wrong, could we incorporate the citation at the end of the statute where, you know, it says,
For implementation.
yeah. Could it go in there? So that way there's some sort of a reference at the end of the rule?
To the CFR. We could.
I don't know, maybe Moana.
I'm not
It
sure
could
what
go
it
in.
is implementation.
To be at the end
possible?
under the citations? Is that what you're saying?
Well, as an implementation,
Yeah, no, because that's not, there's no authority for you. You don't have that's not your authority. You can cite to it in the rule. I don't know why it's necessary. You guys are creating your own rule. Why is it necessary to you can't put it in the citation? Because your authority under the citation is how you're getting the authority to make the rule.
Juana, could you turn up your volume? For some reason, you've gotten very quiet all of a sudden.
You don't have the authority
Thank you.
in your authority to the citation. It doesn't come from the CFRs. That's what your authority is.
So it wouldn't be an
Okay.
implementation of it.
No,
Okay.
no. You can cite to it in the rule, but I don't know why that's necessary. I mean, because you guys
Yeah.
are creating your own rules. It's up to you.
I guess, you know, if folks want to come back and look at the legislative history behind how we, you know, came up with these rules, they can always look back at the minutes and justification memo and see like that's where the language came from. So the other option is if we do use the state's definition about indirect gifts, they just say family. They don't, they don't list, you know, like all these other things, so, not sure what the commission wants to do at this point.
Was there did the State Ethics Commission have a definition of family?
No.
That's surprising.
Yeah.
That is surprising.
Yeah.
Chair, do you have a problem?
Oh, well, it's not my preference. I think, let's go ahead and go over the technicalities that you had
All right. Then
mentioned.
for the technical non-substantive changes in 7-1-6, paragraph C, a gift to a city officer would have to add the apostrophe S for employees to match officers and employees. And then again, at the bottom of that paragraph, after the underscored language, if presumed to be a gift to a city officer or employee, if the gift was given with the city officer apostrophe S or employee's knowledge or acquiescence, that the gift is offered because of the family, I would insert here or household, because there is a reference above to household, member's relationship to the city officer or employee. Those would be the technical non-substantive changes.
And since we're kind of creating our own statute without necessarily referencing the CFR or anything of this nature, I noticed we struck out domestic partner. I kind of,
Yeah, that's consistent with the Code of Federal Regulations. It doesn't include that. But we can include it if we want to.
These are the
we're going
commission's
to-
rule.
we're making our own rule without making reference to it. We're going to have to justify it.
Is that not included in member of the household?
Member of the officers or employees
Right.
household.
I mean, it's
We're
possible that domestic
In the
partner.
same-
The last thing in the list, or a member of the officers or employees household.
It is possible that they could be estranged. You know, I mean, like if they're not, you know, it could be a domestic partner, but not living in
Good
a
point.
house possibly.
Yeah,
That could be a
they have a
situation.
separate household.
Thank you for that reality check.
Well, my preference is to put back to the domestic partner.
Okay.
I'm not sure.
That-
Yeah, sure, right after spouse.
Yeah, right after spouse. After all, we're kind of crafting our own rule. And to that extent, the state ethics rule is kind of non-specific and ambiguous. Maybe they're relying upon litigation, prior litigation to determine what a family member is. But this is very specific.
Maybe will inspire them to revise their rule.
I don't know. I'm not sure.
So, Mr. Chairman,
Yes,
so I think
Commissioner
it's
Fukunaga.
better to be specific, which is a listing of these categories. Because it shows more specific intent about who we're defining in this category. It will help
Yes.
later on if this becomes litigated for some reason.
Yes, I
So I think
concur.
it is better to be specific, even though it's from the Code of Federal Regulations.
So you would agree to put back in domestic partner?
Yeah, we can put other categories in if we want to, because I think, like I said the last time, this listing is actually a proxy for who could be conflicted. Because we don't have a direct measure of what a conflict is. In other words, the domestic partner gets $10 versus $30 or $40. So we're using the relationship as a proxy measure of a conflict.
Well, I think everything's in it except for the domestic partner.
Yeah, so I
think
think
we
it's
have
okay to put it
categories
all
covered.
in. You know, put domestic partner in.
Yep,
It just
and then-
helps later on in guidance in court if we have to litigate this.
Did you get through discussing?
Yes, I did.
Okay.
I covered the technical non-substantive.
And also the director included the technical non-substantive issues of officers, apostrophe S, and family or household that was discussed.
I
Are
wonder,
there any comments?
sorry, this is Mona. I wonder if it makes sense, because you said that someone mentioned that the ethics rules just say family. I wonder
Yes.
if it makes sense to say, and this is just a thought, a gift to a city officer or city officers or employees' family, comma, including but not limited to parent, sibling, spouse, domestic partner, child, blah, 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 or a member of the officer's employee's household. I don't know if that makes sense, but you just kind of, you never know what you may run into. And if someone's not listed, do you only want to have what's listed? Because right now you only have what's listed.
Yeah, we've got to
I don't know,
be
it's just
very
a thought.
specific. We got to just drill it down to the specifics.
Mhm.
So your suggestion is adding employees, family
At the top.
at the
Which
top.
includes, but is not limited to.
Limited to parent,
Maybe
Yeah.
that's too general, but then also, do you really want to be limited to what you have listed?
Mr. Chairman, so if we go broader,
yes,
you'll have to give some guidance to whoever's interpreting this, what
Right?
not included means.
Yeah,
yes.
it may be more complicated to do what I just suggested.
I mean, because if we're missing somebody now, we'll find that out later, but I would think it's
Well,
hard to know now. Anyway, that's my comment.
Yeah,
Yeah,
I don't disagree.
one missing category would be the Hanai relative.
Yeah, we don't want to go
Because-
there right now.
Because that is another one that shows up in Hawaii law. But,
Yeah,
it is noticeably missing from this. So it depends upon how we want to go.
Sure.
This chair has that.
yes.
Yeah, I think we actually touched on this topic in earlier discussion. And our general preference was to go more rather than less specific. So not limited to, just basically throw it wide open to any relative, but that's on that consanguinity chart to the 8th degree. And also high relatives, and that may be something that the public would want to address. And once we open this for public discussion, high relative might actually come up. And we can consider it, unless we really want to put it down.
Yeah. But I would concur with just adding domestic partner for now. And would you, if you add that in, could somebody just repeat it to us how it would track?
Let's say a gift to a city officers or employees, parent, sibling, spouse, domestic partner, child, dependent relative, or a member of the officers or employee's household is presumed to be a gift to a city officer or employee if the gift is given with the city officers or employee's knowledge and acquiescence. The gift is offered because of a family member or household member,
Family or household members.
correct, family or household member's relationship to the city officer or employee.
That does it, doesn't it?
I think that does it.
So no need the family including, but.
No, including but not limited to is gonna cause more problem. Yeah, because it's saying, well, there could be others, but here it is. This is what we meant. And that, of course, they're saying, well, you meant to have more. We want to make it very specific.
All right.
We gotta leave room for some future fights about this.
Yeah.
We will regardless. Intentionally or otherwise.
The public hearings, you hear of.
Oh, yeah,
For sure.
Okay, with that, why don't we go on to the last part, 7-1-7, which is, well,
7-1-7, fair
Yeah,
treatment.
fair treatment.
Okay, so the commission recommended that we use language from Hawaii Administrative Rules 21-7-10. So again, have the language be consistent with that. And so we did that, and the only thing that we added was the word private before organizations. And that is in subsection
3I,
A3I.
yes.
So it says, otherwise furthering a private business interest except where the city has made a city facility or resource available for rent, purchase, or use by private organizations or individuals on generally equal terms, and such use serves a city purpose.
And I think the director has some technical changes.
Yes, in, under subsection A, subject to Article 3, Section 7, Hawaii State Constitution. Those would be the technical additions of the comment. I do have a question for Moana, maybe if I could ask. While this provision has been made consistent with the administrative rules for the state, the Article 3, Section 7 Constitution references to it's kind of to legislative immunity to members of the legislature. The idea would be to somehow make that applicable to council members, if it is. But the language does seem rather tight to the legislature.
I don't know.
So I realize that would make it out of consistency with the administrative rules, but I wonder whether that one phrase up front is something that would be specific to the state.
Well, there is a US Supreme Court case that talks about legislative immunity applying to local legislators, but that is in regard to civil, it shields them from civil liability. It is, as far as I know, based on my research, it's undecided, whether or not, local legislators have legislative immunity from ethics violations. I mean, it seems it would be consistent with, state ethics if we left this provision in, saying it's subject to legislative immunity. We left it in. And in past practice, in answering requests for advice, we have, allowed council members to have legislative immunity. Basically that things that they do in furtherance of their legislative duties, like voting, I guess deliberating, things that are protected by the speech and debate clause, constitutionally for legislatures. We've had it apply to council members as well.
How does that apply specifically in this context? Where does that impact this?
Yeah, so for this context, for instance, we couldn't, so I guess we couldn't like punish, so to speak, a legislator for, the way they voted on something, anything done in furtherance of their legislative duties, but that does not prevent us from, I guess, enforcing things against them for actions taken outside of that context, like administrative things that they do, like dealing with their staff members, dealing with constituents, political actions, all of that stuff. It's not like a blanket exception to the ethics laws.
Well, let me interrupt that. But we're getting confused with immunity. There are two kinds of immunity: absolute, which is the judicial, and we're not involved in that. And legislators have limited immunity. And council members have limited immunity, and that's by law. So as far as they have the right to say, well, I have immunity for whatever gift I gave and solicited, but it's not limited to the extent that it could violate this provision, because it is limited, and the courts may decide that.
Well, why are we doing that?
So I'm not sure how the limited immunity issue affects
I'm not well
7-1.
read here. Why are we doing this?
Because the beginning of this rule cites to Article 3, Section 7 of the Hawaii State Constitution. It says, subject to Article 3, Section 7 of the Hawaii State Constitution, and then it goes on to state the rule.
Mhm.
And that is consistent with Hawaii administrative rules, so what state ethics has. So for state ethics, they're saying that there's legislative immunity for the legislators as to the fair and equal treatment law. So now we're trying to decide,
For the council.
yes, are we gonna do the same thing but for council? Because the law it's more fuzzy as to local legislators. But like I said, there's a Supreme Court case about, saying that there's civil liability. I mean, that there is immunity from civil liability, but there's nothing that is directly on point that talks about ethics commission ethics commission applicability, ethics commission laws applicability to council members in the context of legislative immunity.
But we're not going to put any reference to legislative immunity in this administrative rules. That's something for the court to decide. We've never decided whether or not we can craft immunity for any legislature or council member. That's not within our prerogatives. And that's not what we're doing. We're not trying to craft any immunity and saying you're absolutely immune from this or you have limited immunity for that. Because So we're going beyond what our rules require. We're just saying the Constitution, subject to whatever the Constitution provides, which is true because the Constitution applies to city and state. That's why you have that phrase. I don't think we need to worry about whether or not we have any kind of immunities, because then we have to worry about how you're going to spell out the type of immunities. And we're not, and that's really what, for the court's province to do. Because there's a whole case law on that.
So we should retain the language to the Constitution.
Just retain it because
As
it
a-
applies to the city, and
as
it
it
applies to the
applies to the
city.
city. Okay,
You know, because the Constitution applies to the city, whether or not we're a city, or state agency. And I don't think you want to go any further than that.
These are the exact people we want to, we have to. Here's the violation.
Oh,
oh, no, just the
Officer-
comments at the top, subject to Article 3, Section 7, Hawaii State Constitution. And then,
analyze the word section. That's,
no,
okay,
not for rules.
okay. I don't know.
I think that's.
That's it. Hooray.
Rachel,
Hooray.
Hey,
bottom
so.
line, does anybody have any motion at this stage to adopt the administrative rules as amended during this session for the technical? Does anybody want to make that motion? I can't make this motion,
I'll
so
move.
would you state the motion for the record?
We accept the technical changes that have been proposed.
That's my motion.
And what's the give me the words.
Move to adopt the proposed
Yes.
text of the administrative rules as amended for technical
Well, then-
purposes during this session.
It's Mark Leonard with Monk's proposal. I'll second it.
Okay,
Okay,
sorry.
No, that's good. I stand corrected.
Vice Chair Monk. Yes, Vice Chair Monk has correctly stated the motion.
For the purpose of releasing to the public and holding a public hearing.
Okay, yes. Leland, did you get that? Okay.
For the most part.
Let me know if you have any.
Yeah, I don't want to have to paraphrase it. So with that in mind, we have a second by, Commissioner
Adler.
Is there any discussion? Sorry, I gotta jump on the seat. Are there any discussions? Okay. Now I'm gonna require a vote. You know,
Roll call.
a roll call on this, yes.
Okay, you call it and we'll say aye.
Okay. First of all, call my name, Shelton Jumon, Chair. I say yes. Next, Commissioner, Vice Chair Monk,
Aye.
Commissioner Adler,
Aye.
Commissioner Martell,
Aye.
Commissioner Lynch,
Aye.
and Commissioner Fukunaga.
Yes, in favor.
It's passed unanimously.
So just as a recap, this still needs to go to public hearing. This is just the draft. I want to make sure it's clear on the record. This is just the draft coming out of the commission. It now needs to do a chapter 91 public hearing.
What's the period of time for the public hearing?
There's a
30
30-day
days.
notice period. And then the public hearing, and then depending upon what kind of comments come back in will depend what the next steps are.
All right, well, we got through one hurdle.
Yes, so this is a huge,
Just go
thank you very
rest
much.
of them.
Legal counsel.
It's a team effort.
Lori, Associate Legal Counsel, I'd like to thank the Director and any of the staff members and all of the staff members who worked on this.
Yeah,
It's hard.
Tremendous.
Hard.
Those are
Difficult
difficult
project.
pieces of work.
do we
Yeah.
have any, sorry,
And of course, mentioned, I had the Assistant Legal Counsel. I think she worked on it as well.
do we have any general time frame in mind for when this would actually, when such a meeting might actually take place?
I think it's all a question of just getting it onto 30, we have to publish it in a statewide. Yeah, and then after that, it's wait the 30
On
days,
countdown,
we put it on the website.
And then we wait 30 days and then we hold the public hearing.
So Thanksgiving Day would be the.
Something like that.
Maybe you say the earliest would be maybe within 6 weeks or something
Yeah.
like that, yeah. Public hearing.
I think we've already done
Yeah,
the
December
search about how much it's going to cost to publish in the newspaper, et cetera, I believe.
Yeah, thank you to Jen Hooper for doing that,
Yeah.
so I think she's got all
The
lined
process.
up. She's got lined up.
All right, next on the agenda for discussion and action was whether the Ethics Commission should enter into executive session to review and approve the executive session minutes of August 20th, 2025. And it's my understanding that the minutes are still in preparation. The preparatory stage is subject to more revisions, and that it would be premature to take it up at this time.
I think that's correct.
So with that in mind, I'm going to postpone or cancel this executive session. And depending upon what comes out, we may have this executive session specifically for the purpose of reviewing and approving the executive session minutes of August 20th, 2025 as relates to the director's evaluation. And we may incorporate that for the December agenda. Do we have a meeting in December?
Yes, we do.
Yes.
We don't have a meeting in November.
November.
I won't be here for the December meeting, so just warning you now.
Thank you.
Hopefully we'll get, before on that day. Sure. We have a big party on that day too, don't we?
We usually do.
Usually do.
It's a little potluck.
And
Oh, no,
Could it be
let me
Commissioner
invite
Adler's-
this year.
Adios.
adios.
Then Chair's band is gonna play.
So.
A little performance would be good. I'm gonna bring my guitar on. Okay. Thank you.
Just so that you know, Commissioner Romano in the past brought home Corona. We had a kind of capilla.
Okay. Thank you. Since we're not gonna have an executive session
Yeah,
at this
then I-
time, I'd like to entertain a motion to adjourn.
So moved.
Commissioner Lynch has moved to adjourn.
Second,
Second by
Vice Chair.
Vice Chair Monk. Any discussion? All in favor of adjourning the session? Aye. Commissioner Fukunaga, you raised your hand, so it's unanimous. Thank you so much,
Thank you
everyone,
very much.
for everything that you've done to get us through this meeting.
Thank you.
I look
Thank
forward to
you.
seeing you.